Good afternoon, everyone. My name is Noelle Brennan. I'm the president-elect of the Chicago chapter of the Federal Bar Association. We have a great and timely presentation for you today. And before we get started, I'd like to take a moment to encourage you to become a member of the FBA-Chicago chapter. Membership in the FBA has many benefits. Our chapter is distinguished by a high level of involvement of our federal bench. Membership in the FBA is a great way to get better acquainted with our local federal judges. And we're also proud to host the Northern District's annual State of the Court address delivered by our chief judge. That is currently scheduled for next June 15th. Today's fantastic program is typical of the high quality CLE that our chapter regularly offers. Our recent programs include an employment law seminar, home run motions, business development, smashing the glass ceiling, and government careers panel. We've got an exciting program to come, including an in-person members appreciation event next Thursday, April 28th. So I encourage you to consider joining the FBA Chicago chapter. If you are interested, please go to our website, www.fedbarchicago.org/membership. And speaking of the high quality programs that we put on, we have a fantastic program for you today. And I'm going to give you a short introduction of our panelists, all of whom probably you already know. First, we have Judge David Corr. Judge Corr served as United States District Court Judge for the Northern District of Illinois for 16 years and as a United States Bankruptcy Judge for 8 years. From 1979 to 1982, he served as the first United States Bankruptcy Trustee in the Northern District of Illinois. As Associate Professor of Law at DePaul University College of Law, Judge Corr taught courses on ethics, corporations, corporate finance, constitutional law, labor law, and professional responsibility. And as a practicing lawyer, Judge Corr represented private plaintiffs in the case that determined how Title VII impacted the merger of previously segregated lines of progression in the steel industry. Judge Corr has traveled extensively across the globe to consult on judicial and economic issues and has participated in educational programs for foreign judges in the U.S. and overseas. He's participated in programs in China, Russia, Nigeria, and Cameroon sponsored by law schools, the National Center for State Courts, the U.S. Department of State, and the U.S. Department of Commerce. The bar has praised Judge Corr for his excellent legal ability, handling of complex cases, integrity, and independence. Thank you so much for joining us today, Judge Corr. Next, we have Judge Sheila Finnega, who is a United States Magistrate Judge for the Northern District in Illinois. After graduating from the University of Chicago Law School, Judge Finnega served as a law clerk to the Honorable Milton Shader. She then worked in the U.S. Attorney's Office, where she prosecuted federal criminal cases for 12 years and was appointed Chief of the Criminal Division. In 2000, Judge Finnega joined Mayor Brown as a litigation partner and served as a co-chair of the Chicago litigation practice. She remained at the firm until taking the bench in May 2010. Judge Finnega is an adjunct professor of trial advocacy at Northwestern Law School and a fellow of the American College of Trial Lawyers. She also formerly served as a co-chair of the Seventh Circuit Electronic Discovery Pilot Program. Welcome, Judge Finnega, and thank you. And last but not least, we have our program host, Judge Sunil Harjani. He is a United States Magistrate Judge for the Northern District of Illinois. Prior to his selection as a magistrate judge, from September 2008 through January 2019, he was an assistant U.S. attorney and deputy chief of the Securities and Commodities Fraud Section for the U.S. Attorney's Office in Chicago, where he investigated and prosecuted complex white-collar crimes. During his time as a federal prosecutor, Judge Harjani tried numerous securities and commodities matters and other complex fraud cases to verdict in this district, as well as argued multiple appeals on behalf of the United States before the Seventh Circuit. Prior to that, Judge Harjani practiced federal civil litigation as a senior counsel at the U.S. Securities and Exchange Commission and as an associate at Jenner and Block, and as a federal judicial law clerk. Judge Harjani holds a Bachelor of Arts and a JD degree from Northwestern University. He is currently an adjunct professor at Northwestern Law School, where he teaches white-collar crime and civil discovery courses. Judge Harjani is also a trained and certified mediator and previously conducted settlement conferences for the Cook County courts. Judge Harjani is a fellow of the Leadership Greater Chicago, a board member of the Federal Bar Association, and active in leadership at the Northwestern Law School Alumni Board, the Southern Asian Bar Association, and other civic and bar organizations. Welcome, Judge Harjani, and all of you. We are very excited to have you tell us and all of the attendees here what we should and should not be doing at virtual settlement conferences. And I'd like to just get started. Judge Kaur, can you tell us what are the advantages of virtual conferences, in your opinion?
Well, the obvious advantage is convenience. Lawyers don't have to get on a plane and travel to the courthouse for settlement conferences, and their clients don't. It is, everybody can appreciate. The practice is increasingly national, if not international, and it's expensive, time-consuming to have to travel to a location for a settlement conference. Fortunately, about the time that the pandemic hit, the technology was there and able to absorb a lot of what we do, especially settlement conferences, settlement and status conferences. The other advantage is maybe more personal. In my view, settlement conferences, mediations should be informal. The less formal, the better. I frequently tell the parties in a mediation that if you create a continuum, if there's a dispute, the easiest way to resolve it is one lawyer picks up the phone and calls the other lawyer on the other side, and then try to negotiate a resolution. At the other extreme is litigation. Formal set of rules, there's a decision maker who makes the decision. In between those two poles, there's mediation, which is closer to negotiation. I call it a facilitated negotiation, where the mediator or judge in that case is the facilitator, and then arbitration, which is closer to a trial. So I tried to stress the importance of informality, that especially for me as a mediator and not wearing black robes, I have no authority to do anything. The parties don't have to please me and show that they're reasonable. They could care less what happens. Either it settles or it doesn't. If it doesn't, they go their merry way. I explained to the parties that I don't talk to the judge who's trying the case ever, and that everything's confidential, so they can, everybody can let their hair down and tell me what they're really concerned about. So that informality is important. As a matter of fact, I wouldn't be offended. I suspected one of the parties or one of the lawyers may be offended if somebody wants to sit a beer can on the table as they talk. Whatever makes them comfortable is fine with me. But I think the biggest advantages are the convenience and informality of it.
And I think part of the advantage of the convenience and lack of travel is you're more likely to get the real decision makers. We always say, the person to be there has to have the authority, but the reality is, you don't always get those people, and they're making phone calls. And I have seen now, both the insurer companies that you might get better people or more people who actually are invested able to influence that decision. So that's been great.
I think, yeah, that's a great point. I think that we're all frustrated when we spend a half a day or a day in trying to settle something, and we get to the end and find out that the person who has the final decision is not in the room. They haven't heard any of the discussion, and somebody makes a phone call and tries to summarize what's happened all day in order to get authority. I think that's exactly right.
I think to add to that, it's because of that, it's easier to schedule. So if you need the real decision makers in the room, it's much easier to have them have their video screen open. They're still available to do other work that they have to attend to during the breaks and when we're in the other rooms. I found it's much easier to get a date, let's say in 2 or 3 weeks from my last talk with the parties, to get them scheduled for a settlement conference. Oftentimes with the in-person, especially with needing all the decision makers, the CEO or the deputies, you'd be looking at maybe a month or 2 months out from the last time you talked to the lawyers. So it's much easier to get people in faster, and that helps litigation, avoid unnecessary delay.
And let's not forget that we're not at risk of catching transmissible diseases or illnesses.
There's that benefit as well. And following up on points that you all made, do you find that you are more inclined now to schedule short, perhaps an hour follow-up to a mediation in the event that the case didn't settle, but you want to talk to the parties 2 weeks out just to take the temperature? Does that happen more often, you think, in the virtual format?
Well, David's a paid mediator, so I'm guessing he will take as much time as you need. But I would say for the judge, I mean, we always did that. If we had needed to get him on the phone afterwards, we would. So yes, I do find myself wondering though, do I want to do another video follow-up, or sometimes it's just phone calls is really more effective. So I haven't seen too much change there.
Okay, so the flip side of the virtual settlement conference is that you don't get to be in the room where it happens, as they say, and so what do you think is lost as a result of not being in person, if anything? Judge Hardani?
I can kick it off. Sure. Thank you. So, it's interesting. I think maybe what the audience will probably hear today is that us judges and mediators have a pretty favorable view of virtual settlement conferences. There definitely was a lot of trepidation when we started in 2020, doing them almost exclusively. But I think after 2 years, we have found them to be a very effective tool to use for settlement. There are a few things that are lost that you have to find a way to substitute in the virtual world. One is the ability to have a little bit more sort of what I call impromptu or inconspicuous discussions with attorneys outside the presence of their client. So for example, if I was walking the hallways between various rooms, I would often run into the attorney on the way to the bathroom or getting some water, and I would chit chat with him, and they would feel comfortable telling me what their client was thinking and would give me some intelligence about what they think would work to further move it along. Sometimes I could bring the attorneys, again, very inconspicuously into the hallway and just chit chat with them in an informal way, much more natural way. On virtual, you can still do it. You can still move people to the main room, but it's a little bit more abrupt, right? It's in front of the client and you have to say, well, I'd like to speak to the lawyer privately. And you also don't want to leave the impression that the client is missing out on something, or you're ganging up on them by bringing the lawyer outside. So you have to be a little bit more careful in how you phrase your ability to move the attorney into the main room to have a private discussion. It doesn't feel like you're excluding the client. So I think that's one thing you have to be more careful about. I think the other thing is there are times when, mostly on the client side, the client just doesn't have the level of focus that they have when they're in your courtroom, for example, for court-ordered mediation. So there are a lot of distractions at home, you know, people's pets, people's kids, things happening in the kitchen. It gets close to lunchtime. All of a sudden, you come back into the room and the client is not there. They're in the kitchen getting lunch ready. So you do run into those kind of issues where you're not 100% sure if the client is completely focused on what's happening. And, you know, it's easy for them to sort of check out of the process, if you will. So that's something to lose. There you go.
I'm sorry.
We're going to talk about those tech issues later, but that was a good preview.
That was planned. That was planned.
Speaking of distraction.
Where did I go?
Um,
We lost David now. Okay.
Something must have turned off. I'm sure he'll jump back in. I can keep going. Noel. And I think the last thing I'd say is sometimes while you're really trying to be informal, you are trying to get people to talk, have a conversation with you, make them understand that there's no one's going to win or lose today. There's no rulings. You really want them to talk to you and tell them what they want, particularly on the client side. Sometimes you need a little formality, especially maybe the business folks, a little formality in the process. They're in the courtroom. They feel a little bit more pressure to get something done. It's less easy to click off and just say goodbye. You really have to kind of let them go, if you will, like just, dismiss them from your courtroom or your conference room. So sometimes in, the small number of cases, a little formality can help where it's less easy for people just to leave the conference with no settlement. So I would say those are the few things that maybe are lost in the virtual world.
And I want to hear from Judges Finnega and Core, but I just wanted to follow up on one question or one point that you made, Judge Harjani, which is the formality. Do you find that the lawyers are less, I'll admit, sometimes particular judges and can be a little more intimidating than others, and in person you as the lawyer may feel a certain amount of pressure to take a settlement that perhaps you don't think is adequate. Do you find you have less persuasive powers over the lawyers, or not so much?
I don't think so. I think that, a lot of it has been lawyers just getting used to the process and having confidence. I think in general, lawyers like to be in person, right? They have a view that when they're in person, they are the most effective in advocating for their client. And, there's a lot of truth to that. I think once that, the year and a half passed and people saw that it's worked and cases were settling, I haven't found any differences as lawyers have gotten used to virtual mediation.
I probably disagree with that a little bit, but only on certain cases, and maybe we'll get to that. But I think if you took all things being equal, if we could magically just plant everybody with the snap of a finger into the the rooms, the jury room, courthouse, or JAM's offices, and have a face-to-face, that would be preferable to all of us staring into a computer screen for hours on end, because there is something with the direct communication, and there's nonverbal cues, and just it's I think Judge Harjani said it can be a little more impromptu. I had an in-person conference yesterday that the parties wanted in person, and we had a large number of people, and some flew in for it. And I was thinking, because of this program, how would it have happened, or could it have been done as well by video? And I think on that one, it couldn't have. And we were moving, people were able to stand in the hallway and kind of talk with each other. In a settlement conference by video, the judge or courtroom deputy or JAM's employee is controlling the breakout rooms. But I do also think there's something to be said for the direct sitting across the table from somebody in certain cases. And you don't have that always by video. And so I would always, if we had the same convenience and the people with authority and everything else, I would rather have in person. But I don't think we're going to go back to that. I mean, I think it's, you know, you just can't match the convenience. So.
Yep. Judge Core, I think your mic is off.
Okay. I'm not a big fan of body language in hearing a trial or in an arbitration. I'm not too concerned that I don't see all of the body language. But in a settlement conference or mediation, I feel differently. I agree with Judge Finnega that the judge or a mediator is trying to establish some type of rapport with the parties, to let the parties know that you are an honest broker and that they need to trust the judge or the mediator in that circumstance. And I think establishing that rapport is much easier in person than it is having talking heads on a computer screen. And so I think that there is some loss in not being in person, not being able to reach out and physically touch somebody, and doing it virtually. Now, you know, the extent of the loss, I'm not sure, but all things being considered, especially in a settlement conference or mediation, I would prefer to have it in person.
I think that I would encourage lawyers, and this is what's happened with me because I've been kind of content to do them by video. It's the lawyers who have come to me sometimes and said, for this case, we think we need it. And the other example was somebody, and they thought their clients, for that particular case, it was important that we be in the courtroom and that they be with, you know, I was a judge, maybe that helped in that case, but they wanted it. So I think lawyers should, you know, if you think it's, you know, your client's best, you know what the dynamics are, the challenges. So if you think in person would be helpful, you know, obviously you should not hesitate to ask for it and suggest it.
You know, I was going to add, you know, I think I agree with what you all said, but I think if we were to magically say to everybody, you know, all settlement conferences are going to be held in person now, I bet we would be inundated with requests for virtual because somebody can't travel or there's some cost issue or scheduling issue. I'd say more than half of them, of the ones we set, we'd get people asking for virtual.
And sometimes, and we should be agreeing to it more now that we've seen, you know, I think it would be very, I don't think the magistrate judges should be taking the position you always must be in person. You know, the insurer has to fly. It's very expensive and it's not necessary in every case.
And do you find ways to, for instance, in a situation where the lawyer tells you my client might need to be told X, Y, and Z? I know that comes up in in-person settlement conferences all the time. Like you said, Judge Harjani, you run into the lawyer in the hallway and they might tell you, you know, my client is stuck on X point and perhaps a discussion about X point would facilitate the settlement. Are you still able to get that type of information from the lawyer and then have an opportunity to talk to the clients that need perhaps movement on a particular topic or issue?
I can jump in quickly. I think you can, but it depends on the circumstances. So sometimes the lawyer and the client are in the room together, on camera together. So moving them to another breakout room has no effect. You really need them to say to you, Judge, can I call you separately, or, you know, from outside the hallway, can I make a phone call to your chambers and talk to you? So that's a little bit of a bigger, you know, ask, if you will. Lawyers are less likely to do that than to just sort of catch you on your way out. Judge, let me follow you out, you know, before you go to the other room. That's an easy thing to do. So I think you lose a little bit of that.
And I would discourage lawyers from not being in the room with their client because I think that raises other issues. So I wouldn't draw from that it's better to not be in the room with your client because, you know, again, we'll speak to that, but I agree, it's a problem.
Let me ask the judges a question. one of the advantages of settlement conferences is that you get to talk to the parties and lawyers ex parte. And I'm a big fan of pre-settlement conference, pre-mediation phone calls ex parte. I want the lawyers to tell me what's really going on in the case. And they're more likely to give me the real scoop if the other side's not on the phone. So I don't have a problem. I tell everybody beforehand that I may pick up the phone if I got a question and call you, and you're free to pick up the phone and call me. But in the actual settlement conference, it's assumed that you're going to caucus with the sides separately. Now, these conversations that you have in the hallway, or the lawyer calls you, I suppose that all falls within the scope of this is a settlement conference, so it's okay. But what about in preparing for the settlement conference? Are you comfortable calling the lawyers or having them call you to tell you? I mean, sometimes a lawyer will say, we could get this settled, but my client is being difficult on this issue and I haven't been able to convince him. Is that okay?
I think it's okay. What I do, my standing order says call me if you want to have that. Sometimes I initiate it, even if they don't, if I think it will be helpful. But I always enter an order. It says I had a telephone conference with plaintiff's counsel, and I always just say for discussion of settlement issues. So I want everybody to know I talked to the other side. But yeah, I think those calls are helpful. I wish I had more time to do them because they're very useful, I would say.
Yeah, I do a pre-call in every case, and it does take up a lot of time. I agree, but I like intelligence. Beforehand, I like to be able to know what I'm headed into and maybe have a strategy in mind that I'd like to use, a few tools of mediation I'd like to employ, and so I will have a joint call with parties, and usually somebody will give me an indication that they're speaking a little bit vaguely. I can tell they want to tell me something, but they don't want to do it in front of the other party. And I break them out on the phone. So our phone system here has the ability to put people into separate telephone rooms. And so I'll break them out by telephone into separate rooms and jump between the two rooms to get that intelligence. And I find it very useful.
Interesting. Yeah, so there are ways to handle it virtually. You don't need to run into somebody in the hallway, I guess. So let me ask you this, Judge Finnega. Do you believe that the conferences held virtually result in the same rate of settlement as in person, and why?
I think generally they do, but I do think there are, and there's no way to know this for sure, I do think there are times when it makes a difference. And I was thinking about my past cases, and I don't think there's any that I've had since COVID when we've sort of been forced into this, where I would say, oh, if we'd only been in person, that case would have settled. But then I'm thinking back to some other cases that I've had, pre-COVID, and the ones that come to mind, there were cases where, and I'm remembering one in particular, and it was two businesses, but they were hairdressers and very high, expensive hairdressers. And I think there was, poaching of employees, and we had difficulty with that. And it got to the point in the settlement conference where we brought the two gentlemen in, and they were like the lead hairdressers. And the lawyers were told, and of course we had agreement to do this, I would never force it. And the lawyers were told they could observe, but they could not say anything. And these two men sat, across the table from each other, not right across, but at opposite ends of this table. And it was fascinating to hear, and it was, how they delivered it and the sincerity and what they said and the direct communication, and then believability, as I said, that all made a difference. And I think that would have been really difficult to do by telephone. And I've had some other cases where the business people sat down directly. And then other cases maybe where you've got an individual party, a client who is just, for one reason or another, more difficult. They need a stronger personality or mediator, and and yeah, and really emphasizing whatever it is you're saying. And I think face to face, that's much better. You're looking them in the eye. I notice with these laptops, I mean, when you try to look someone in the eye, if I do that, you might be looking at the top of my head. If the plaintiff or defendant I want to talk to happens to be at the bottom left of my screen. And so you have to actually look at the dot at the top of your laptop, and it's, it's difficult. And doing that, and for the mediators, we don't get a break either. So we are looking at this, and I finally, I have a stand-up table because I just can't sit for as long as it takes. And so I think there are some cases where I believe probably might not have settled if we hadn't been in person. But in general, I don't think it has made a difference or makes a difference in most cases, and the video works fine.
Judge Corr, do you want to comment?
Yeah, there's some cases where, let me put this gingerly, the lawyers are a pain in the butt. And
how did you really want to put it?
and you need to wrap them over the knuckles with a ruler, as the nuns used to do. And it's harder to do that virtually than it is in person. You don't want to embarrass anybody in front of their client. But you need to take the lawyers aside sometimes and tell them to just cool it, that this isn't really their case, it's the client's case, and they're free to advise the clients in any way they want, but they're not helping by being so litigious. So that's one. The other circumstance I can think of is where you've got a room filled with people with different interests. And if in preparing for the settlement conference, that hasn't been taken into account, because from the judge's point of view, from the mediator's point of view, you didn't know that until you got there. That and you need to separate people out in a way that's more inducive to resolving matters. But it's clunky trying to do it virtually. It's much easier if you can say, well, let me talk to these folks, and you've already got a breakout room set up for them, and you can do that. But those are two circumstances where doing things virtually can be a problem.
When Judge Corr just reminded me too, in that situation, sometimes it's really effective to have, when you've got multiple parties, you might have multiple insurers and multiple defendants, and they can be talking to each other while we're talking to one party or another. And so on these bigger cases, you can have lots of different rooms, and they can be out. And I've given in one or two cases like a directory, so they knew where everybody else was, and encourage them to be talking when they're not meeting with me. And you really can't do that, as I said before, because they have to have somebody set up that breakout, or they're going to be picking up the phone and having side conversations to talk with one another. And I think that's a loss.
Yeah.
Judge Harjani, I think we kind of combined two of the questions that we had talked about having. One is, are settlements, do the conferences result in settlements when they're virtual as frequently as when they're in person? But also, are there types of cases that just aren't conducive to a virtual settlement conference?
Yeah, I think I agree with the other judges on this type of case, which is where there are really multiple parties. So, sometimes you have 4 or 5 physical rooms, and you've got people in different places. And then sometimes you need to bring them together, certain groups together, break certain people apart. You need to have hallway conversations with certain people. And in those cases, oftentimes what the judge is trying to do is collect money from all these different people. that have different interests and different needs. And sometimes they want to know what the other person is doing, and the other person doesn't want to reveal what they're doing. A lot of that's easier to manage in person than it is jumping breakout rooms and creating new breakout rooms or bringing people together and apart. You can do it, but I find just walking the hallways between all the rooms that we have in the hallway, the jury rooms, the conference rooms, the witness rooms, the chambers, I find that to be the easier place where I can go and collect the money I need to present a global offer to a plaintiff and then go back to them. So I would say in those really in the multi-party cases, I would prefer in person versus virtual.
So what do you see as the future of mediation post-COVID? Do you think there will be mostly virtual settlement conferences, mostly in person, some sort of hybrid? What is your thought, Judge Harjani?
It's a good question. I think everyone might have a different view of it. If I had to predict, I would say more than 50% virtual. And I think that's a lot will be driven by the attorneys and the clients as a result of the cost and scheduling issues. And I think for the most part, for most cases, it works. So I think, you know, the run-of-the-mill of the federal court system, your civil rights cases, your employment cases, your prisoner cases are generally, I think, for the most part, will be virtual. I can see certain, you know, business cases at a high dollar value with sophisticated lawyers. They're willing to spend the cost to fly to Chicago, to be in the courtroom, to get something done. But I suspect that we will be getting a lot of requests for virtual because most cases are not high dollar in the federal court. Maybe different at jams where people are paying for the mediation, and so they are generally of higher value. I think hybrid for the courthouse is a little bit more difficult because of technology. So it's easier to have one side on video and the other side in person, that hybrid form. But to have a few people from a party on video and a few people from a party in person is more difficult and cumbersome. I'd rather just have the whole side on video. And that's because we just don't have the courtroom set up like a conference room, for example, at an attorney's office where they have the full tech options available. So I would say mostly more than 50% virtual. I would be very cautious of a hybrid because of the tech, but I would do it in person if people want it. And in those rare cases where I think they're really needed.
Yeah, I agree with that. I think that I think there may be more hybrids than Judge Harjani thinks, especially in some of these international cases where you've got principals of one of the parties. There may be more than one, and they may be in different countries. And so it wouldn't be cost effective to bring everybody in for a settlement conference, and that hybrids may work, and that's true sometimes even if it's a domestic situation. So I think that there will be a lot of hybrids out there where most people are in person, but you've got one or two people on a screen someplace. But I think that having open Pandora's box with the virtual conferences, I think we're stuck with it. It's going to be, like it or not, that's going to be the future.
You know, the thing I've noticed sometimes with, it's both hybrid, but also when lawyers are with their clients sometimes. And so like right when everybody's just sitting in front of their own computer screen, you actually have a pretty good shot of, and you have that conversation. When they're in an office, sometimes they're sitting way at the back, and maybe based on where the camera is, you can barely, you know, make out the facial features of people. And so that's, you know, not ideal. And I notice even like we do have some technology, and we've been using it for some of the judges' meetings where we have some in person and some not in the room. And it's not ideal because the people in the room are kind of having a conversation together, and then all of a sudden you'll hear a voice, from the screen, and somebody's piping in and talking. So, I think it can be done, but I really am a little weary of hybrid. If we have to do it, we have to do it. I once actually went to a law firm because we had somebody from Saudi Arabia or somewhere, and they had the technology, and they serve better cookies and juice, than the courthouse. So.
But even symbolically, where the lawyer and the client is in the same room at the lawyer's office, and the lawyer sort of hogs the screen. One of the things I'm trying to do is to let the client know this is your case, and we're not just talking about the law here. We're talking about whatever concerns you. And so I insist that the client have their own screen. Now, technically that gets to be a problem sometimes because you get feedback when people are in the same room and the lawyer says, well, I want to be able to talk to my client at a moment's notice. So, the technology has to be right, but I want the client to at least have equal access to the discussion as a lawyer. The lawyers are litigation oriented. They're thinking about this as a piece of litigation, and this is a different animal. So it's important, I think, that the client have equal access.
The reason I had said before, I thought as a lawyer you might want to be in the room with your client is because I have had situations where they're not in the room with their client and they say things, which as a mediator, I was found very telling and was happy to know. And I'm sure the lawyer was like, oh my God, why did you just say that? So, if you're in the same room, maybe you can kick them or, so your lawyer might be doing good for the client by not letting you blurt out, that the case is a cancer and I must end this at no matter what, or, whatever might be said, but might not be best overall in the negotiation. Somebody once said that they never let their client talk in any mediation, and that they get the best outcome when their client doesn't talk. I think it depends on the client, what they're going to say and how well they do, and do you have an insurer there who doesn't know anything about the case, and is that going to help? But make your plan in advance and you do what's going to be best for your client. And if you need to be there, I think you should be there with them. But and if they're effective and they can talk and they can help you get a better outcome, then prep them and let them talk, and that's great.
Yeah, I think the best setup I've seen, whether the client's in the room with a lawyer or not, the best setup is where everybody has their own computer and has figured out to use one speaker and one mic to talk if they're in the same room, so there's no feedback. So you get the best of both worlds. The thing that is most concerning to me these days, and I've seen a lot more recently, I'm not sure why, maybe because people are starting to be more active and moving around, is the conference room view, where I know I'm big on a screen in the conference room, but my view of them is this big. They are thumbnails around a large conference table, and I don't even know who's who. I can't see the client, barely see the client. I can barely hear them because they are far from the microphone. They're sitting at the end of the conference table, so they can view the screen that is on the other end. And I'm sure technology-wise, it's expensive and it works really well, but I would actually just prefer everyone to be on a laptop, because then I would get each their faces on the box and I could actually see them better.
So I want to move on to some more questions about advice and tips that you would give to us as the lawyers for ourselves and how to prepare our clients for virtual settlement conferences. But I first want to let all the attendees know, if you have questions that you would like the judges to answer, please put them into the chat, and we intend to have at least 20, maybe 30 minutes at the end of the seminar to questions from the audience. And also the CLE code is 21422. Okay. Judge Finnega, so in your experience, do the lawyers and the parties have different quote unquote courtroom etiquette when they are on screen versus in person?
I would say lawyers, I have not really noticed that a difference. They seem to be, dressed like you would expect. And for parties, it's hard to say because sometimes parties, I think parties probably are more likely to, if you're talking about clothing, for example, the fact that they're going to the courthouse, they're going to meet with the judge. I'm guessing they are dressing up a little more than when you catch them at home and they're in the kitchen. It sometimes happens, or wherever they are. I don't doesn't really matter to me what they're wearing as long as they're attentive and I have their attention. And as I think, someone mentioned already, that's not always the case. The kids are bursting in or the dogs are barking, the doorbell rings. So it is a problem. But in terms of etiquette, I feel like they are listening, and I have not noticed anything where I would, felt like I needed to say something, or where I felt like it was undermining our ability to get to the finish line with a settlement conference.
Mm-hmm. Yeah, I think you may have gotten a good batch there, Judge Finnega, because I have had probably the last few months in particular, and I'm not sure why, a fair amount of attorneys not professionally dressed. And I've had to, my courtroom deputy knows to tell them, Judge Harjani requires business dress for lawyers, just like you were in a courtroom. So maybe I just have a bad run of several cases, but I have seen some of that where nobody would dress like that in my courtroom, but on virtual, they somehow feel it's okay not to have a tie on, for example.
But no tank tops, right?
No tank tops. And the clients, I never mind. Again, the client is more important is they're engaged and they understand what's going on. They are talking to you. I think what mediators and judges really want is a client to talk to you. Tell them what you're feeling, what you want, how's litigation gone, what do you want to get out of the process today. So that for the client side, that's the more important part. But we're talking about etiquette. I think for the most part, the lawyers have maintained etiquette. I'd say the only exception I see is dress.
All right, and so I have to take back what I said because I just remembered something which I thought was a big breach in etiquette. So sometimes I actually now have had to give my phone number, my cell number, to a party, to a lawyer, to say, send me a message when you're ready to come back in. Now we're using the chats more, but there were times when I would, for one reason or another, they had my cell phone number, and so that's fine. I mean, I'm not worried about that. That's my courtroom number, it's my court issue phone. So, but then, so the settlement conference ended. And maybe like 2 weeks later, I get a text on a Sunday from this lawyer about some issue in the case. And I was like, very unhappy about that. And so, of course, I texted him back and said, do not text me about the case. But I thought, that some lawyers should know better than that. But other than that, that's my one example.
Yeah. I expected about 50% of mediations to hear the phrase bad faith or disrespectful. And so I think you have to be careful, even though I don't really care about how people dress within limits. I think you have to be careful as to what the other side's reaction will be, whether they will interpret that as being disrespectful to them and their clients. I think that can be handled in a pre-settlement conference phone call, and the topic can be either raised by the judge or by one of the parties. But I think just as a matter of prudence, that you really have to be careful about dress.
Mhm.
So Judge Harjani, I'm curious, what did you do when the lawyer showed up in non-professional dress?
So I don't do anything, which is for the exact reason that Judge Core mentioned. I have my
Yeah.
courtroom deputy handle it. So my courtroom deputy will either call the lawyer on the phone, or if they're in the same room, just we'll say something casual. Judge Harjani requires professional dress for the mediation, so I don't do it. I have someone else handle it for that very reason.
And what about, I can't imagine that this would be the case, but do you find that the attorneys are any less respectful or attentive or deferential? Because it is a very different dynamic.
Mm-hmm. I actually think there are advantages to being virtual that help with that. So I found lawyers to be just less exhausted, for example, because I think when they're in the courtroom or they're in a conference room and they're stuck there and they're captive, and sometimes they're waiting an hour, for you to come back because you've had a long session with the other side. I think we talked about virtual really has advantages and has downsides. One of the advantages, I think, is lawyers are a little bit less exhausted having waiting around all day for you because they're doing other things while you are with the conferencing with the other party. And so that less exhaustion, less stress, sort of takes down the temperature a little bit. So I found, sort of the opposite, which is some lawyers are much more calmer and much more steady in how they handle it than sometimes in the courtroom. There are exceptions, and everyone has different experiences, but that's just something I've noticed.
So Judge Core, what tips would you give lawyers to help them be most effective in a virtual conference that is somewhat different from effectiveness in in-person conferences?
You're using technology, and this is a technical production, as it were. So you need to be fairly fluent with the technology. And if you're not, you need somebody in the room who can handle the technology. If you want to share a screen, then you need somebody who knows how to share a screen. If you need, before the conference ever takes place, you need to understand it and to prepare for whatever's likely to come up. Now, if you're in the courthouse, you've got somebody there who knows how to handle the technology. But even the setup of, we've been talking quite a bit about the setup of your office. Will you and your client be in the same room? Will you have separate computer screens? What's the technology behind that? Are we likely to have feedback? If I need to communicate with the judge, how am I going to do that? Are there other people that I need to communicate with? How do I go offline and communicate with them? If there is a case that I think is dispositive, how do I communicate that to at least the judge, so the judge can take a look at it, and how can I do that quickly? But all of that needs to be thought out before you ever get to the settlement conference itself.
Yeah. Judge Harjani, Judge Finnega, do you want to add anything?
I'll add that from my perspective, most of the technological issues are happening on the client side. That is, the client these days, after 2 years, I think attorneys are very used to logging on now for court hearings and motions and statuses and settlement conferences, that it's no longer something unique. But if the client's in a different location than the attorney, where I personally have the most tech issues is on the client side. And so my tip would be to really not just ask your client, casually, do you have a laptop? Okay, you're going to get a link. all you gotta do is click this link, you know, that morning. It's gotta be more than that. I think really, if you ask where you're gonna be, is it gonna be quiet? What computer are you using? Some people have a really old computer that really can't handle the audio, video, internet. Some people that have really bad internet connections that slow it down, so they're frozen the whole time. I think he's going to ask a lot of questions about what their internet, what their computer is, where they're going to be, and have they had any experience with video conferencing? Because sometimes it's a little bit more than just clicking a link. You know, as you know, you've got to troubleshoot a little bit sometimes to get that video and audio working. And they don't have that background in troubleshooting. The conference starts becoming a disaster. It starts late. It stresses everybody out. The other side gets annoyed because they're waiting around until this issue is solved. So I would suggest really work with the client if they're in a different location and ask a lot of questions to make sure they have the necessary means to log on.
I mean, I would think even doing a dry run with your client, and the other reason for doing that is to make sure you see their background, right? Just to make sure everything looks okay and try it out. We used to schedule before every settlement conference, my courtroom deputy would schedule kind of a rehearsal to make sure they could get in, that, you know, everything worked, they know how to mute and turn on and off the camera. And that was a hassle because then you're scheduling all these people. And so we finally just said a half hour before, everybody's got to be ready to go. I think we started in an hour and then it was down to a half hour. And usually it is the clients, but sometimes it's the older lawyers and not their clients, and they look bad when their client is there and their lawyer's having trouble connecting, or they have, you know, that feedback because of, you know, whatever, maybe because the client, I think Judge Kaur said when the client's in the same room, that's where you have that feedback. That's so irritating when you hear your own voice as you're talking, you know, delayed, and then you have to tell everybody, you know, please mute so that we can, you know, get going, or you test and find out who is the cause of that problem. So I think that would be worth doing. And I noticed with as we got later in the winter, you know, with the shorter days, and when I'm at home, I have some natural light, and it was great. And then all of a sudden, I noticed by the end of the settlement conference, I was kind of sitting in the dark, and then I turned on a light, and it was terrible. It's all this glare, and you couldn't see. So one thing I did, I just looked online. It was $40, and I have two kind of cheap lights, and they just stand. I'm not using them now because we actually have light again. But you put them on the side of your computer, and they worked. But you have to kind of figure this out as you go. And we're going to be doing these, I think, for a long time. So it's worth the investment in a good computer and, you know, lights if you need them.
Yeah, I don't, you've probably noticed I have one of those energy efficiency lights, so it keeps turning off and I have to raise my hand to turn it back on. But we've touched on some of this, but it seems like a lot of the advice that you would give to both the lawyers and the clients revolves around their use of technology. So what haven't we talked about from a technological preparation angle that you would encourage both lawyers and the clients to focus on prior to a virtual settlement conference?
You know, I think I've gone through the technical issues that I've seen, and the ones that are most concerning to me, and you can't always predict it, but when the client is not able, even, you know, sometimes they have an iPhone and they're using that, but sometimes I find out last minute that they are having to dial in and be on the telephone because of technical issues, and that's a party. And so to have them by telephone is really not good. And so I think going forward, if we have that type of issue, I probably will insist on it in person, you know, unless there's good reason why. I probably have everybody say, if you cannot tell me you're going to have access to a laptop so that you can be by video, then we're going to do it in person, unfortunately.
One of the things we've done for clients who just don't have the technological capability is we FedEx them a small tablet that they can use for a deposition, and then they just send it back to us. And that does cut down on it's it's the stress of the technological mistakes, I think, that are so difficult for us and frustrating for you all.
Well, sometimes it's our problem too. I mean, we have trouble sometimes at our own homes, the internet, something happens, bad connection day, and then you're fiddling around. So I think that we can be sympathetic for that reason. But let's try and avoid as much as we can the things that shouldn't be happening if we prepare.
Yeah, I had a case once with a pro se claimant who lived in rural Alabama and did not have access to a computer. And what we wound up doing was him going to the local public library and finding a librarian who could set him up with a link, and we did it that way. But again, all of that requires some preparation, and we could not have done it on the spot. And you have to think about all these things before you get there.
Yeah.
And you
I'd
mentioned,
also
David, the documents are a problem. And so
Yeah.
that's, I'm not sure I've mastered how you give control to somebody so they can show a document. Sorry, Judge Georgiani.
No, please, thank you. And along those lines, I'd say, another tip is don't have your client use a cell phone for the video conference. I personally don't allow it. I recognize that some clients don't have access to the technology, and so the cell phone is all they have. And I'm sympathetic to that, but what happens is it just ends up not working well. So they can move it, right? Your cell phone's never very steady, and people like to walk around. Sometimes they move it and they take it with them, so their screen is moving along. They get text messages and phone calls on that same device, and so you constantly hear their beep, you hear their phone ringing, they're trying to turn it off. All of that is very, very distracting to the point where it can really affect how the conference is going. So, I usually tell lawyers, if that's all they have them come to your office or find some other methods like the library or send them a computer. But like Judge Finnega, I would rather have it in person than have a conference with a client on their iPhone.
And Judge Harjani, you mentioned this earlier. What are your thoughts about use of conference rooms and the large screens? And I think like the lawyers might think that that's a better idea than perhaps the judges do.
Yeah, I think it can work if you set it up right. So really you have to sit close to the microphone and closer to where the camera is, so that the other parties and the judge can actually see the person. And that's just a matter of testing it out ahead of time. Having somebody else, just run a test and see the IT guy can see you clearly and see your facial expressions and see who's in the room. So it can work. It just requires some thought and preparation.
I had one question that just came to my mind, and I'm curious to know how the other panelists would answer this. So it's very convenient to do it by virtually for all the reasons we've discussed, but there's also kind of a nice, do you find any loss of the kind of time pressure and urgency when you had people in person and they had to catch a plane, or they're going to get home and they have to, they know they have things they have to do. And now that we're all by video, that, that's a little more relaxed and maybe things are taking longer than they would. I mean, in the overall sense, they're shorter because we don't have commuting and all that, but the actual negotiating time, because we don't have, or how do you handle that? Do you have a hard stop just so people can, get moving and not think that they can, take all day?
I can tell you from my perspective that I've had a lot of conversations with people on the train on their way to the airport because they didn't want to miss a plane. But that's one of the questions that I ask in the pre-mediation session. Are there any time issues? These things tend to, if they're going to settle, they tend to settle at the last minute anyway.
Right.
So if everybody knows that the last minute is 3:45, then we can get to it rather than waiting until 5 for people to get serious. So, but that, again, in terms of preparation, that's one of the things you want to know.
One of the questions that came in through the chat, which goes to your point, Judge Finnega, is does the fact that clients don't have to go through the hassle of traveling make it easier for them to just say, no, I'm not going to resolve this, or more resistant to compromise?
I don't know. I would think, sometimes there have been insurers who, if you insisted they were going to come in a smaller case, they would probably not come. And I have had cases where they send a potted plant, who's local and doesn't know anything anyway. But I would think usually the parties have so many other reasons they want to settle the case that if they to not show up because, I don't know, that would surprise me that they would that would make a difference in their willingness.
Mm-hmm.
Yeah, one of you folks have the problem of having cases hit your desk for settlement when one side or the other is not really interested in settling.
You don't think a district judge would ever refer a case for settlement when they don't want it, do you?
No, never. But that's a different animal. That's a totally different animal. And I don't have to worry about that anymore because they have to pay jams and my fees. So at least I know somebody's motivated to be there. But you can get cases where nobody's interested in settling at that point in the case. So it's got to be much tougher on you.
I think they would worry about, first of all, they obviously have to have some authority, and they're going to have to make a pre-settlement conference offer of money or demand. And then, I think they would worry if they came in and then said, okay, we only have, very, very little beyond that without telling us in advance. And so I think parties are more likely, if they're smart, to tell the judge in a pre-settlement conference call, we'd be willing to come in for a settlement conference, but we need you to understand, and you tell us if we should cancel it. But we have very little authority beyond what we're going to put on the table. And so we don't want to waste your time or anybody else's time. And we don't want, to be, but if you think we should go forward based on that, then we're willing to do it. That's really the way to handle that.
I think that, the question goes to sort of what we've been talking about, which is that category of cases, which admittedly is small with, the attorneys are really going at it and maybe don't like each other. The clients may be a little bit hard-headed. They're, worlds apart in terms of their demand and offers. And, they need the formality of the courtroom, of the judge and the mediator, the pressure of having, spent the time and the money to get down to the courthouse, to sit there, knowing that they may not be going home until they reach a settlement. So you're well past the 12:30, 1 o'clock. Now you're into 5, 6 o'clock in the evening. And, no one's going home until we finish the conference. Those categories of cases, I think, work a lot better in person for all the reasons we've discussed. But that's not the majority of cases that we all deal with, right? The majority of cases can get done in 3 hours. And, in that respect, the virtual works just as well.
And this is probably not, it doesn't matter if it's in person or virtual, but how do you handle the phenomena that there's not a lot of movement till the last 45 minutes of the entire day, all day settlement conference or even all afternoon settlement conference? Because I do think there's something to sitting in the room as the lawyer or the client, and as you said, kind of the time starts ticking away. So in a virtual setting, do you feel like you're able to sort of create that same kind of pressure? I think this is what you were touching on, Judge Harjani, but I wonder if there's if in those instances the virtual format is as successful. Or I guess how do you create the pressure that you would normally be creating when you're sitting in your chambers and they're sitting in the room next to you in the virtual format?
Yeah, I think I can go first. I think time, as you mentioned, hard stops, and I always give a hard stop in a conference for that very reason, and I think that generally achieves the goal of getting it done. And the beginnings, everyone knows it's going to move slower because you're having a lot more conversation, you're figuring out the need and interest. As you move a little bit later in the conference, you're doing a little bit more of the number negotiation, so that the movement naturally comes a little bit later in the conference. But I think short answer is time. Time limits goes most of the way to doing the trick.
So I wanted to remind the participants that there are materials, there are handouts, and you can find them in the chat area, and they won't be available after the conference is done, so please make sure you download those now. So here's another question from one of the attendees. What is your biggest pet peeve for settlement conferences, either from in-person, pre-COVID, or virtual, and possibly the new hybrid formats?
All right, well, I don't know if this is my biggest pet peeve, but sometimes when we schedule these settlement conferences, we're very busy. We reserve the time. We have standing orders that say what they say. And then sometimes I'll get, and this happened recently, which is why it's on my mind, where a party got the plaintiff's letter, and then when it was time for the defendant's letter, kind of said, well, I can't reach my clients and this isn't going to settle anyway, and so it's off. And of course that doesn't, maybe you can do that at jams as long as you pay the upfront fee. And David won't have a problem with that, but we would, you face sanctions for that. So of course that settlement conference is going forward, where there will be a problem, but kind of a cavalier attitude, like, oh, we need to continue it for some reason, or we need more time, and these dates are, our time is really being pulled in so many directions, and so when we set aside time and we prepare, and you have to prepare and have your clients ready, and then we're there till impasse. And I would always say, sometimes parties will say, I don't think it's going to settle now. They're into the conference, halfway, so I don't want to make another move or something. And and I say we're here till we're at impasse, and we're going to keep going. And when you are making your final move, make sure you announce it. But we don't just stop because it's you don't like the direction it's going. So that's I guess that's a warning too.
I would say, go ahead, Judge Cole, please.
No, I was just going to say, related to that, where the demand is $1 million and the offer is $100, and the one side comes in and says, I'll move 1,000. The other side says, well, you're only moving 1,000. I'll move 1,000. And it's 9 o'clock in the morning. And you're saying this is going to be a long day if we keep taking these baby steps all day. At some point, before 3 o'clock in the afternoon,
well before,
somebody's going to have to take a realistic view of this case. And so the judge or the mediator is sitting there trying to move that along. But some people, some lawyers just say, I'm not moving any more than they do. And you can't get there from there.
I would add, I think a pet peeve would be when I ask, the attorneys in private session, in caucus, we walk through the facts, they tell me why their case is good. And I say, what do you think the challenges are in the case? And I get dead silence. Or they say there's nothing. Or they'll say something vague like, well, juries are unpredictable. It's like, well, you haven't really thought, you showed me you haven't really thought through, the case, because no case is perfect. And if it was, you probably wouldn't even be in a settlement conference trying to compromise. So it shows me that you haven't thought through, you haven't talked to your client about where the holes lie or what the difficulties are had. You haven't had that hard conversation. And you're just dumping it all on me.
Or they might be fighting you and, pushing back on you. So not even helping, or, instead of being neutral,
right,
saying, oh no, we're definitely going to
disagree with everything you say when you start pointing out that, witness is missing or the video doesn't show what your client's testifying to. They push back and start arguing with you. That really, it's private session. This is your chance to be frank and honest. The other side's not here. Take advantage of it to help the case move forward.
Yeah. Most cases are not going to resolve in a settlement conference or in mediation on the merits. It's just not going to happen because the judge is not going to give you an advisory opinion about it. They may at 4 o'clock say, you really ought to reconsider that view, but they're not going to give you an advisory opinion on the matter. And so the lawyers make a mistake when they think they have to convince the judge or the mediator of the merits of their position. That's not the basis for resolving the case. There are risks. If you think you have no risk in the case, then you're in the wrong place. It's not going to settle. Why would you settle if you think you got 100% chance of winning, other than litigation costs? So there are risks, and so a lot of the mediation has to do with how you quantify the risk involved, and whether there are other issues in play other than winning or losing this particular piece of litigation. So, but the lawyers, sometimes the lawyers want to try the case in a settlement conference or the mediation, and that's really not productive.
What are your opinions on the use of, or do you do this? Do you try to get parties to agree to arrange? Do you ever suggest that you're going to give a mediator's recommendation for settlement? Are those tactics helpful sometimes? And why are they sometimes and other times not?
I often, I think everybody always lets lawyers hopefully, test the waters. So they do it in the early couple moves, everybody's making their small moves. And then you'll hear a party say, I'm just so disappointed with their move. I mean, this is ridiculous. They're not here in good faith. They're too small. And then I might say something like, well, where do you need them to be? And so why don't you make a conditional move? Like you make a bigger move, but condition it on them coming back with a particular number where you think, it would be reasonable. Now that's a bracket. And sometimes they'll do that. And then the other side will counter with their own bracket. And I think that helps the parties see that, it's not quite as bad as it looks and get us moving. But, then you can't ultimately keep going with brackets. But I think it's a little helpful if you can get parties to do it. But some don't want to do that because they don't want to signal where they might be willing to settle. And so, but as a mediator, we don't want to spend our time or your time in a hopeless case. So after a while, we have various techniques that we might, say, is there any way you're ever going to get to a 7-digit case or 5-digit, whatever we're going to do, some bright lines that are really bright, so that you don't feel like you're giving away your position. But if we're that far apart, we're not going to keep going. Or maybe you propose each side gives you a confidential range, and then you try and get them to move on those, and there's different ways, but you're not going to just keep going all afternoon with small moves. It just doesn't make any sense.
If a brackets don't really work if the gap is too big. You have to get within hailing range before brackets are effective. They can be very effective, but you can spend all day negotiating the bracket too. And as far as the mediator's recommendation is concerned, I will ask the parties whether they will entertain a mediator's recommendation. But I caution them that I'm only going to do this once. I can't recommend one thing and then find myself involved in negotiations at that point. I'll make a recommendation. You say yay or no. You can counter it if you want with the other side. But I'm not making another recommendation after I make that first one. So it can be useful, but the parties need to know that you're not negotiating for them.
I think it's good that you ask, because sometimes parties, if they know you will make a recommendation, then they might not negotiate the same way. And a party is entitled to say, I don't want to recommend a recommendation. And I've had cases where the parties left and then a Rule 68 offer was made and accepted, on the final move. And frankly, if they say, I don't want a recommendation, they're probably not going to accept it anyway, right? So what's the point?
Yeah. I think the recommendation is really when you've got you know it's going to break the impasse, and you can pick that number based on the intelligence the parties have given you. So I would do it in cases where I have a really high confidence that there's going to be accepted. I don't do it as a Hail Mary where, the conference ends unsuccessfully and, this is the last Hail Mary. Let me just throw a number out there and see what happens in a week when they email me privately. I try not to do that because I don't think that's helpful. I think I try to get the intelligence to have a high degree of comfort that both sides are going to say yes. And I think that mediator's recommendation there has the best value.
So I think I have time for one more question. I hope this isn't from one of my opponents, but the question is, any advice for responding to high plaintiff demands in employment lawsuits to make a settlement conferences more productive?
We don't get many of those.
Yeah, you don't know what you're talking about.
I've never sent one, certainly.
I guess I'll start off in saying, we're sort of used to it. There's a range of what a plaintiff's demand is, and the ones that are high but are not outrageous, right? Just based on your own experiences. So I think we're used to it, and I always tell the defense lawyers, don't be as outraged, don't be as disappointed. Just take it in stride. Let's get through the conference. Let me do my job. You've done this many times. They start high, but ultimately we get to a reasonable place. Think about all your employment cases. Don't most of them settle? Well, yes, Judge. Well, did they settle even though the plaintiff's demand was high? Yes, Judge. Okay, then let's use that experience and take it in stride and take a deep breath and don't be so disappointed all the time. I think we all had a nickel for every time someone said they were disappointed in the offer. We'd be retired by now. So that's sort of the way I approach it.
I've seen, and this isn't something the judge does, but there have been cases I've seen where the defendant said and I think this is, discussions that lawyers have, but maybe they shared for one reason or another, that they're based on the demand, their client doesn't want to have a settlement conference. And so ultimately, the plaintiff, if they really want one, ends up sending something that's not sky high to induce the defendant to actually have a settlement conference. And it might have settled at the same number in either case, but if your client just is like, can't stomach scheduling a settlement conference when they have an offer that's or a demand that's so high, you can have that discussion and say, I need to convince my client to do this. So I understand you want to come in at that number, but if you do something that's based more on the back pay and something more realistic, I think we can get to the same place perhaps, and I can actually get my client to the table.
Yeah. It's helpful sometimes to ask before you relay the number how they think the other side is going to react to it. Whether it's an offer or a demand. Sometimes they haven't really considered whether the other side will consider it insulting to get that number. I've had to tell people, I said, I've been in the other room and I've heard what they're saying, and if I take this number back, I think this may be a short day. And sometimes it is, and sometimes it isn't. But I've taken a number in, and the defendant said, "Okay, thank you. Maybe I can get an earlier flight," and left. I mean, it's helpful, I think, sometimes to remind the parties that this can be interpreted not as a negotiation, but as an insult.
But I also think sometimes when I get a case and they're closer together, and it's harder. And I mean, it's not harder. It just they have less room because they came in more reasonably and they made those compromises before. So you get this number, and you think, oh, how hard could it be? But each side is like, all right, well, I didn't come in with all the room to move on one side or another. And so it's not necessarily easier to settle because the plaintiff came in lower or the defendant started higher.
So I think we just have a couple of minutes, and again, thank you so much for your participation here. Could each of you give us attorneys sort of one piece of advice that you often find yourselves wanting to give attorneys in your settlement conferences?
This is mediation. It's not litigation. You don't have to fight over every little statement that's made. You don't have to convince the judge or the mediator of the rightness of your position on the merits. Put on your negotiator's hat and not your litigator's hat when you come in.
And just to jump on that, I would say, and do that in advance when you're preparing your clients too, so that they're not, that they come in and they understand what this is about, and this is not your time to shine, and that they come in with their expectations, and you're not putting all your weight on the mediator to finally, for the first time, explain that there are some risks and downsides, and certainly that you're not fighting us when we actually try and do that. To try and get us closer together.
Yeah, I would say don't hesitate to ask if the judge can speak to you privately before the conference. I think we always want intelligence. We always want to know what the challenges are with the client. Are there management issues? Are there things that really, they want to hear, they need to talk to you about? The more we have in intelligence, the better we can prepare and strategize and guide the negotiation and mediation in a way that is most effective. I always appreciate when lawyers, on my pre-call say, Judge, can I speak to you for a few minutes privately without the other side is there. I've never, ever once regretted that phone call, and it has always been helpful to me.
Very useful. Well, thank you so much, and thank you for your generous donation of your time and your intelligence for us. And I hope to see you all perhaps in person someday soon.
Okay, great job, Noelle. Thank you so much.
Thank you.
Thank you.
Take care, everyone. Lisa, or can I want to just give you the CLE code one more time. 21422, and remember to download the handouts, please. Okay, take care, everyone.
All right, bye-bye.